Okay, it's 10 a.m. now. Thank you everyone for signing on. We're Bryson Insurance Brokers, and we like to put on these webinars for a quick resource of education for our clients, prospects, and people in the industry. Today, we're very fortunate to have Shubham Gupta join us. Shubham came here in 2012 as a claims adjuster, very passionate, very well respected, and is now an independent claims adjuster. So who best to know about a bill of lading than a claims adjuster? So welcome, Shubham. Thank you very much for coming.
Thank you, Linda. I'm humbled.
Okay. Well, we realize that there's various bills of lading. We recognize that there's an airline, rail, ocean bill of lading, and a inline transit. So today, for the next few minutes, we're going to focus on the inline bill of lading. So perhaps we can touch base on the bill of lading, one that is perhaps issued by the carrier and one that is issued by the shipper. Perhaps you can give us a brief explanation.
Yeah, so basically before jumping onto that, I would like to just discuss a brief about what is a bill of lading. So basically, what is a lading? Lading is a load of cargo, and bill of lading is any bill or receipt that represents that load of cargo. So in a sense, bill of lading may have, it could act as a receipt for the exchange of that goods from the shipper to the carrier. It could act as a contract of carriage, which in most situations it is, but it's not a contract of carriage in its entirety, because there may be like so many contracts other than this bill of lading that may be in place, or there may be so many correspondences, verbal or written, that may have been exchanged between the parties contracting, that may affect the contract of carriage in its entirety. And thirdly, it may act as a title document in case of a negotiable bill of lading, which you will see usually in ocean or overseas shipments. I have never seen a negotiable bill of lading in a trucking scenario. So a negotiable bill of lading is like where you see to the order of where you have to present the bill of lading to receive delivery. So it becomes a title document. So that's what the bill of lading is basically. And now I would just jump to your question, which was what is the difference between carrier and a shipper issuing the bill of lading? Now, there is a difference between issuing and preparing a bill of lading. So what is issuing a bill of lading versus preparing a bill of lading? Now, the carrier may have his letterhead format where there is a logo of the carrier at the top of the document, and then he provides that document to the shipper to fill in. Basically, this is the case where the shipper is preparing the bill of lading, but the carrier is still issuing it, or it could be vice versa. But the fact of at the end of the day, why it becomes really important is who is issuing the bill of lading. Because that's the first question I always ask if it's not clear. Because suppose, and actually currently I'm dealing with a claim right now where the shipper issued a bill of lading, and it was in Ontario, and there was no space provided for declaring the value of the shipment. Now the shipper cannot rely on saying that, okay, there was no space provided for declaring a value of the shipment when the shipper was himself issuing one, right? So if the shipper is issuing, if it's a shipper issued bill of lading, the shipper cannot come and say, okay, you cannot limit your liability because the bill of lading was not issued respecting the statutory regulations. However, if the carrier is issuing a bill of lading, it should respect the statutory regulations in place. And for 8 out of 10 provinces, there are uniform conditions of carriage in place that would tell you what's the format of the bill of lading that should be, and they're more or less the same. They are really nuances that we will be discussing later. But yeah, I mean, 8 out of 10 provinces would tell you what's the format of the bill of lading that should be issued, and every carrier must respect that format. I mean, and yeah, so that's the basic difference. If the shipper is issuing the bill of lading and it's not respecting the statutory regulations, the carrier may still be able to limit its liability, right? Because there's nothing like where the shipper cannot blame the carrier for not issuing a proper bill of lading. However, if the carrier is issuing a bill of lading and it's not respecting the statutory regulations, then obviously the carrier cannot say, okay, that the carrier may not be able to limit its liability. So that's the basic difference.
So they should have the option to either have the shipment carried on a release bill or a declared bill of lading.
Yeah.
And I think that we have to also recognize that, yeah, and being prudent about the bill of lading. On a US shipment coming inbound, it's on Carmack, and outbound out of Ontario is under the HTA. So recognizing that as well, there's different provinces in Canada. Are there different statutory regulations on the bill of lading?
Yeah, so basically, as I discussed earlier, as I mentioned earlier, that 8 out of 10 provinces do have their uniform conditions of carriage, and there are only 2 provinces that do not have their uniform conditions of carriage, where the conditions of carriage would depend on the contract of carriage. And the 2 provinces that do not have is, one is Prince Edward Island and one is Newfoundland and Labrador. These two, except for these 2 provinces, all the remaining 8 provinces have their statutory regulations in place respecting uniform conditions of carriage. Now there is another differences now, and more or less these uniform conditions of carriage are same, but I would like to highlight one major difference is, like, while most of these do become part of contract of carriage as a matter of law, but it's not always the case. Like in British Columbia, it does not, the uniform conditions of carriage will not become part of the contract of carriage unless it's specifically endorsed on the bill of lading as a reference and it's provided to the shipper. While in Alberta, it does become, as a matter of law, it's part of the contract of carriage, and even if it's not endorsed on the bill of lading, you may be able to limit your liability. Basically, British Columbia and Alberta are the 2 extremes, and rest everything falls in the middle of it. And because there have been case law, like Hoskins is the leading case law in Alberta, where it says like the bill of lading was not issued. I don't remember exactly whether it was not issued or whether it was not signed, but the carrier was able to limit its liability. While in British Columbia, there's a case for Shooters Production, where it clearly said, okay, you did not provide the bill of lading to the shipper, and it was not provided to the shipper until after the delivery and it got damaged. They were not able to limit their liability. So yeah, I mean, consider these 2 as the extremes, and then everything else will fall. But it's always best to respect those regulations. They are there for a purpose. So please respect those regulations, prepare and issue your bill of lading accordingly. And that's the best way to do. Always give layers, always give your shipper an opportunity to declare the shipment value as well.
And speaking about the declared value on the bill of lading, when a driver goes into a terminal or goes into the shipper's yard and they get the bill of lading, now, if there's a declared value on that bill of lading, should they presume that perhaps dispatch is aware of that and accept the bill of lading? Or what's your recommendation for the driver? What should the driver do when he sees a declared value on the bill of lading?
So basically, before jumping onto that question, I would just like to say that what's the intent behind declaring a shipment value? That's the most important part, the intent, right? So what happens why does a carrier is expect to be fully liable for a shipment just because there is a value written on a piece of paper known as bill of lading? Why? Because there's an intent associated behind the entire concept of a declared value shipment. And what the intent is, it's giving both the parties an opportunity to choose limit of liability. If for the shipper, they are choosing that, okay, I'm giving you my shipment, so you better be liable for the full shipment value. I do not want to deal with your statutory regulations or limitation and all that. And for the carrier, is giving the carrier an opportunity whether or not the carrier has enough appetite for that kind of a risk to accept the risk, then whether or not the carrier is willing to accept the risk for that kind of a shipment, and then do they have sufficient insurance coverage to accept that kind of risk, that kind of liability. So it's basically all about the intent, and so that and there should be sufficient opportunity given to both the parties to declare or not declare the value. And that's why, like, if a driver sees a declared, oh, the bill of lading, and if the driver sees, oh, there's a declared value shipment, definitely it should be confirmed with the company. Okay, like they want me to sign a declared value shipment, so should I sign it? Have there been discussions in place with you guys? Have you charged? Because once there's a declared value shipment, and if the carrier is accepting that kind of extra risk, they might want to charge additional freight. to the shipper. Or they might want to even procure shippers interest insurance, where they might want to just insure the entire shipment on a first party basis, right? So it's all about the intent and the discussions that have taken place between the various parties. And then, yeah, definitely, if the driver is seeing that there's a declared value shipment, definitely there's no harm in cross checking, right? It's just a call. And but there are certain situations that have happened where the declared value actually happened without actually declaring the value of the shipment. But that's like going, there was a case that I remember, and where they just attached like an invoice at the back of the bill of lading, and they referenced the invoice number on the face of the bill of lading. I personally, I'm not in complete agreement with the case, but yeah, there was a situation where, so yeah, you have to be really careful with that as well. If you are referencing any invoice numbers or anything on the face of the bill of lading and you're signing it, just make sure. And the best thing is, like, if you are issuing your own bill of lading, just issue your own bill of lading as well, like respecting all the regulations. That's the best and the safest way to go.
So if they're issuing like their own bill of lading, should they have terms of carriage on the reverse side of the bill of lading, or just the face sheet of the bill of lading?
So yeah, I mean, with respect to terms of carriage, you can put them on your website as well. Like, I mean, that's a good practice. Like, put your conditions, and like FedEx and they all the big companies, they do have their tariffs and terms and conditions mentioned on their website. And you can always, like, even in your email correspondence, is just put a link. Okay, if you want to review our terms and conditions, here, click the link or something like that. I mean, at the back of the bill of lading, like, I don't see I mean, I don't even remember when the last time I saw a bill of lading that had terms and conditions printed at the back of it. But again, if it's a fine print, and then you may not be able to, like, really limit it. It's all about the front of the bill of lading, and the statutory regulations clearly depict how your front should look like. It should have a shipper, it should have a consignee, it should have a space to declare the value, it should state weight of the shipment and all that. And again, like, weight of the shipment is, again, that's another topic where you can say, okay, $2 per pound applies. Is it gross weight, net weight? What if the weight is not declared properly and all? So that's another thing where you have to really, like, look into it when it comes to a claim scenario. I once had a case where basically the shipper misdeclared the weight of the shipment, right? And he declared it beyond the actual weight of the shipment, and he wanted $2 per pound on that. I said, no, that's not going to happen, because it's a misdeclared weight and it's kind of a misrepresentation. The other thing is, it basically is a threshold. Okay, it does not necessarily mean it's the value of the shipment. Suppose if I declared $50,000 on the face of the bill of lading, right? It does not become the invoice value of the shipment. It does not become the shipment value. It just becomes the threshold. The shipment may still be $20,000. It could be misdeclared. It could be anything. The shipper still has to substantiate the value of the cargo in every scenario, right? Because I once had this argument, and the shipper was not willing to substantiate the value. Hey, I declared the value of the shipment. You can declare 100,000 for a $20,000 shipment, but that's not gonna fly, right? I mean, you have to, like, substantiate the value of the shipment, right? So yeah, I mean, so that's what it is.
The details have to be correctly declared on the bill of lading.
Yeah.
Now, speaking about the bill of lading, and when we come into, again, we'll take a driver going into a terminal, and he doesn't have the opportunity to get out of the truck. He doesn't have the opportunity to view the loading of the freight, but yet he's expected to carry that load under the bill of lading that's issued by the carrier. What would you recommend that driver do to protect the company? He hasn't had the opportunity to view the dock.
Yeah.
He has not had the opportunity to review the load being loaded. He has not had the opportunity to count the load.
Yeah, so that happens all the time, in my opinion, especially with and this becomes really critical when it comes to refrigerated shipments. It becomes really critical because, okay, like, there have been situations with me, like, where the shipper wants to rely, okay, there is a fine print on the bill, almost every, like, the shipments are subjected to terms and conditions, and they are subjected in good, and they are received in good order and all that, and the driver signs the bill of lading. I mean, but that declaration is only going to fly so much, right? I mean, it's first of all, First of all, like anything that is so standard and anything that is so boilerplate, which is present on every document, that again is really it's a standard document. They're just printing every document with that kind of a declaration. As it is, it's hard to fly. And but the thing is, if your driver is not allowed on the dock, the first thing you have to mention is shipper load, store, and count. Definitely do that. Even if you're allowed on the dock, but you're not allowed to probe the temperature on the bill of lading. Oh, sorry, on probe the temperature of the shipment. Mention that, like not pulped by driver, pulped by shipper, or something like that. Okay, because this, I mean, refrigerated shipments are so critical when it comes to a claim scenario on a refrigerated shipment. It there is so much to, like, you can dig deep, like so much into it. And it then it would depend like how the reefer unit ran. Like I have seen claims where I would get a reefer download and they would say, okay, the return air was this high, so you are done, like there is a claim. I said, no, like the return air is warm because your product was warm. Because if you see the cycle, the how it works is basically, if it's a fresh produce, it breathes, it respires, it releases energy, right? So if even if your supply air is fine, it definitely is gonna get warm by the time it returns, because your product was loaded warm and it was releasing energy. That does not mean my reefer did not run fine. Trust me, I've had these arguments so many times. And again, like, but yeah, so interpret your reefer download correctly. I mean, that's the most critical part. Don't just rely on one column. There are at least 4 critical columns that you need to see, or at least 3. One is the set temperature, one is the supply, and then is the return temperature. And for a warmer shipment, refer on the return, while for the colder shipment, refer on the supply. Right, and that's the main part for a reefer shipment. And as far as the driver is concerned, if he's not allowed on the dock and is not allowed to probe the temperature, at least upon delivery, if the shipment is getting rejected, make sure the driver probes the temperature, because at that time they cannot say no to you. They are rejecting the shipment anyways, right? So probe the temperature, take pictures, keep a thermometer with you, take pictures depicting the temperature of the shipment, and then obviously request instructions. Again, like, they would most likely abandon the shipment, and that happens again all the time. But it's definitely not a good practice on their part. There are actually there are statutory regulations in place to deal with that kind of a situation. In fact, I am currently dealing with that kind of a situation where the shipment was abandoned, a $75,000 shipment. They just abandoned it and did not provide any instructions. We ended up salvaging it to mitigate the loss, and obviously we send the salvage check to the shipper, because we are not the insured is never, so the trucker is never the cargo owner. Okay, no matter what, the trucker never owns the cargo. So do not do anything without taking instructions from the shipper or the cargo owner. And then, yeah, but there is an interesting case law that I came across where there is a responsibility to mitigate damages at law, and you could be held liable as a shipper or the cargo owner for your failure to mitigate the loss. And then there will definitely be, like, you can, that would affect the claim settlement, definitely. And I am currently dealing with such a claim where, yeah, I mean, because we could have gotten so much a higher salvage value when it comes to a perishable product, but they didn't seem to bother about it for 10 days. And I said, okay, and the claim gets reported. Again, report the claim right away when if it's a temperature issue. Like, do not wait for anything, because it's really critical. The time is of essence. And yeah, with respect to drivers, they should always keep a thermometer whenever they are using, like, carrying a reefer refrigerated load. And yeah, that's what it is.
Well, I know with refrigerated freight, it's extremely sensitive, whether it's loaded warm, whatever. I mean, it's a beast of a different nature. So most definitely some great tips there on the reefer freight, as well as if a driver does not have the opportunity to view the freight, count the freight, mark it SLC. That is your only true defense on the bill of lading. Now, we do have a question, but I also want to say, on the bill of lading, it's also a document that, if there's something that's astray, the driver should make notation on the bill of lading. It really should. If there's packaging issues, whatever.
Oh, definitely. And make sure, like, if possible, make sure it's signed with okay, just signing is not sufficient. Make sure there is a date and time, right? And yeah, that's because I get bills of lading like all the time, and where it was there is a sign, random sign. I don't know who signed it. I don't know what was the date it was signed. I don't know what was the time it was signed. And again, like coming back to reefer shipment, time is of essence. Like how much time the entire loading process took to load the shipment, even that is of so critical. That is a critical question, because if the warehouse was not maintained at the proper temperature, then, and if you spend 8 hours just loading the shipment, it's going to affect the temperature, right? I mean, so yeah, I mean, that's why probe the temperature if possible, for sure.
Okay, now we do have a question. What should the driver do if there is something incorrect with the bill of lading?
Note it down, endorse it, get it signed if possible, but endorse it with date and time. If you see any irregularities, endorse it on the bill of lading. Just make sure it's endorsed properly. It has a date and sign stamp, and it says, okay, the bill of lading says X amount of cartons were loaded, but they were only Y amount. Y quantity, or it says 20 cartons appear on the bill of lading, but there were only 15 loaded. Just mention, as long as you're documenting everything, you will be good to go. As long as it's in writing, so that there's no confusion, right? And I mean, and again, it would depend what kind of irregularities are you talking about, right? At the end of the day, if it's a beef shipment versus they are loading furniture, that's not gonna, like, obviously, I mean, that's not gonna
or steel,
right?
Or steel that is rusted or marred, or
I mean, actually, that comes to a really interesting question on conceal. Like sometimes
concealed damage.
You would not know the nature of the shipment, and that becomes a really interesting scenario when it comes to claims. I actually once dealt with a claim where the entire shipment, instead of an entire shipment, they put stones in it, in a containerized cargo. And it was coming from China, and I said, like, okay, stones came in. Instead of furniture, they replaced the furniture with the exact weight of stones in it. So that's another thing. But yeah, I mean, it would depend on the irregularities, the extent or kind of irregular. But endorse everything.
Well, I think we have to note that the bill of lading is a document that is a record or a snapshot in time. So if something is astray, definitely mark it on the bill of lading. We do have another question here, and the question is on probing the cargo temperatures is great. What other best practices can you think of to share to help drivers mitigate the risk?
So probing is one, just make sure your reefer is running, and make sure you pre-cool the trailer. Pre-cooling is one really critical part, because when you see the reefer download, there should be a pre-cooling period of at least 3 to 4 hours. Make sure there is a active signal device in the cab, tractor cab, where the driver could see that signal device from its tractor cab while driving, because like most, if not all, most policies would have a warranty as well with respect to that there should be an active signal device that would alert you as soon as the reefer breaks down. Now, I had an interesting claim like that, where the reefer did break down, but it was only for 15 minutes. It only broke down for 15 minutes, and it was a high value shipment, and they rejected the entire $150,000 shipment just for 15 minutes. And it was like there was a spike for 15 minutes like this, right? And yeah, I mean, it's so make sure like you have that active signal device in the tractor cab, and pre-cool the trailer for sure. Pre-cool your trailer for at least that should show on the reefer download. Preserve your reefer download, make sure. And yeah, the other thing is, you can actually even look, if you're allowed on the loading dock and all, you can see where they are putting the temp-tail recorder, like the Ryan recorder, the temp-tail recorder. Like there is a perfect spot to put it that would always tell you the like there's a best place to put it, which is at the back on the side of the pallet, on last pallet on the tail end. And I mean, again, you won't be able, I mean, as a driver, you may not be able to do much about it, but there are questions raised actually. Like, and I raised that question all the time, where, okay, where was the temp tail recorder kept inside the shipment? Because just by the location of the temp tail recorder, it may not give you exact readings, and it may not match with the reefer download reading. But go with the reefer download. Reefer download is the most critical part of any temperature abuse claim.
Okay, well, we're going to have to move along. We are starting to run out of time. So if you have any questions, we invite you to put them online so we can get them answered. And as well, just a reminder on the winter conditions, the one way to mitigate your risks on reefer loads is make sure that you have enough diesel in the reefer.
Definitely.
Traffic conditions can hold you up for hours. I know it seems like a very basic 101 thing. However, we have an influx of claims in the winter because of not enough diesel. So that's another one. But I would like to kind of wrap this up on the bill of lading. We have an airline bill of lading, which we understand is like a higher valuation. And then we go to pick up the freight. And it's on an airline bill or an ocean bill. What would you suggest that we do?
Yeah, so basically, suppose if it's an ocean bill of through bill of lading, like suppose if it's a freight forwarder who has issued a through bill of lading from warehouse to warehouse, and he hires an inland carrier to pick up the shipment. I mean, always issue your own bill of lading, in my opinion. And you can always mention in the terms and conditions saying, because ocean bill of lading, there may be something like an Himalaya clause where the carrier or any agent of the freight forwarder may be able to limit its liability based on that ocean or house bill of lading, depending on whether or not there's a Himalaya clause in it. Now, when you issue your own bill of lading while picking up such overseas shipments, make sure you mention that, okay, like my maximum limitation is $2 per pound. However, subject to the limitation of whatever appears on the ocean bill of lading, or the house bill of lading, because most likely that would be less than $2 per pound. And again, $2 per pound is the maximum, not the minimum. So you can always, just to be on a safer side, always mention $2 per pound. But again, subject to, there's an interesting case on CN Rail, actually, Jacob, I don't remember the name of the case, where they basically discussed the application of the Himalaya clause, and then they discussed about who is the shipper for CN Rail, because it was hired by, I think it was hired by the shipping line. And so basically whosoever hires you becomes the shipper sometimes, and that's another angle. But yeah, as far as the carrier is concerned, you need to make sure that you issue a bill of lading, present it to the shipper, get it signed with, again, like presenting it to the shipper and getting it signed is another important, it's really important. It's because you may issue a perfect bill of lading, but if it's not signed or endorsed by the shipper, it becomes a piece of paper which has no value whatsoever, right? I mean, and again, it would depend on the province as well. Like in Alberta, you may be able to limit your liability even if you have not issued a bill of lading, while in British Columbia you will not be able to limit liability if a proper bill of lading is not issued and endorsed and signed by the shipper. Present it to the shipper, right? And yeah, so that's when.
Well, and I know that this is probably a very remote issue, but we do have the provinces in Canada. We have touched base on that, but it is winter and we do have ice roads. So what about Northwest Territories?
Northwestern Territories, they do not regulate this area, so all they can, like, if you are a carrier operating in, and again, like, there is a Motor Vehicle Transportation Act on a federal basis that clearly states wherever the shipment originates, that's the regulation that's going to apply unless otherwise agreed. And again, like, if it's Northwestern Territories, I haven't dealt a case in a Northwestern Territory yet, but they do not regulate the area. So your terms and conditions will be guided by the contractual terms and conditions.
Okay.
Yeah.
We do have one more question. Can you recommend paperless software for bills of lading for drivers to use from tablets or mobile phones?
Okay, I'm not really aware of the software as such, which that would be paperless, but yeah, I mean, I'm more on a claim side, but I'm on the top of my head, I'm not aware of any, but I can definitely look into it and get back to you for sure. I mean, definitely there would be like software that could exist where you could properly sign and document and everything. And again, signature and endorsing is really important. I cannot stress that more. I mean, you have to make sure it's properly endorsed.
Okay, we're going to move right along. I'm not meaning to cut that part off, but there's another question here is, do you, any suggestions on how to best train drivers on the bill of lading? And have you seen anyone rewarding drivers for following best practices in filling out the bills of lading?
Again, like I'm on the claim side, so from the second part, I'm not sure if, but it's not gonna harm you if you definitely like you should reward the best your driver if he knows. Educate your drivers on the bill of lading. Educate them, tell them what is what, tell them the importance of signing a bill of lading, tell them the importance of declared value shipment, tell them the importance of probing the shipment temperature, tell them the importance of how like why you should endorse. It's not okay. So I've always followed this in my life. Like if somebody tells me to do something, but if I know why you are telling me to do something, yeah, because I'm a curious guy. I always want to know the why portion of it. So if your driver knows the why behind it, then there would be a better probability for him following the best practices rather than if you're just telling him do that, do this. Tell him the why. Tell him how crucial or critical it is for them to follow these practices, because then otherwise the entire company may be right. I mean,
Vulnerable.
yeah.
And I think that's so true. As far as the best practices, educating new drivers, educating existing, as far as the transportation, they know how to drive, they know how to pick up and deliver, but, maybe just some drivers meetings, get in touch with them and show them.
Show them the paper piece
exactly.
of show them the bill of lading and do a small present. It will take 10 minutes perhaps, and tell them like what's the importance of doing all these activities.
Yes. Refresher courses,
Yeah.
always helpful. Now, the last question that we'll have time for today is, what claims do you see that can be easily preventable but very common?
So I think the most in a reefer shipment, I can like again, I see claims that could be easily preventable with respect to reefer shipments, because I've seen claims where the driver has no idea that the reefer was not running because there wasn't a working signal device. And then I have seen claims where you could have easily limited your liability to $2 per pound. However, there is a contract in place where that basically holds you liable for the full shipment value. And then
Under a shipper's contract.
under a shipper's contract, or and then but your insurers are not aware of it, and then your insurers would be limiting it to $2 per pound, which may be just $20,000, while the shipment value may be $100,000. So try and avoid those kind of scenarios. And if you're actually endorsing such sort of contracts, make sure your insurance broker knows about it and the underwriters know about it. But with respect to like the best practice, if you follow the best practices, it becomes really easy for the claims person to deal with the claim when everything is put in writing. That's the best part. From point A, when you pick up that shipment, if you see any irregularities, just note them down, right? And again, like there are only 5, so it's a strict liability on a carrier. Again, I get these arguments all the time. I was not negligent, and I said no. I mean, it's a strict liability. There are only 5 defenses, or like.
And why waive them, right? You have
Exactly.
5 defenses.
Yeah.
Okay, so I think that we are going to wrap this up, and I think the closing comments on this is treat the bill of lading as a snapshot in time. Feel free to make notations on it that will protect you in the case of either damaged packaging, counting, anything that's irregular. And as well, if you don't have the opportunity to view or count the freight, make sure that the bill of lading is marked SLC. And as Shubham says, document, document, document. So we would like to bid adieu, and thank you very much, Shubham, for coming.
Linda.
A very well-respected individual. He is an independent claims adjuster, and we truly appreciate you coming.
Thank you, Linda. Thank you for arranging this. Thank you guys for attending this and listening to me.